Hello everybody, good afternoon. Welcome to this afternoon's National Silver Academy e-Nugget series. Today's topic is about knowing your consumer rights and protecting yourselves. Now, my name is David Koh and I'm an adjunct instructor at the Singapore Management University. It's my pleasure and my privilege to be able to share with you something about your consumer rights today. And I hope that you'll find this session interesting and exciting, because certainly I'm excited to be able to share with you and to be able to partake in our learning journey together. Now, before we start, we need to take a Facebook poll. So I believe you're all in Facebook and you should be able to see the poll. The poll should have a yes, no, and the question is, are you familiar with the types of consumer rights in Singapore that protects consumers? All right, so please take a few seconds to key in your answers. I'm also very curious to know how much you know about consumer rights. I know the government has for many years been trying to, shall we say, advertise or to promote or to highlight these rights. Sometimes it's the KCASE, the Consumer Association of Singapore, sometimes they do it. Sometimes I believe the Ministry of Trade and Industry may have also tried to do it. Nevertheless, I think that a lot of what I'm going to cover today may not be totally familiar with all of you or with some of you. And I'm very curious to find out. So please, again, I said, take part in this poll, give me some feedback, and then again, we can also do some checks as to whether the topics are relevant to all of you. Okay, so I see that you have responded and it seems like the majority says no. Okay, so I think you will find today's talk very interesting then. Pay attention to the rights that you have, and then we'll take some questions towards the end. All right, so in order to understand your rights, the protections that you have as a consumer, you need to understand as the background, the rights and obligations that you have. Where are the sources of these rights? So there are two main categories, right? One category is what we call as contract law rules. These are the common law rules, the rules created by the judges and the courts. And they talk about things like the formation of a contract, offer, acceptance, consideration, intention to create legal relations. It talks about what are the terms of the contract, whether they're expressly written down in the contract, or maybe they are just implied. And then it also covers rules around vitiating factors, factors that can undermine the contract because there was, for example, some sort of misrepresentation or a mistake or incapacity on the part of one of the parties, etc. So that's one category. The other category are the rules that come out from the statutes that the Singapore Parliament passes. So just to explain, a statute is like a law. Parliament would pass laws, and these laws, these statutes are examples are like, for example, the Sales of Goods Act, the Supply of Goods Act, the Hire Purchase Act. What is very important today is two statutes known as, number one, the Consumer Protection Fair Trading Act, Cpfda, and number two, the Unfair Contract Terms Act, the Ucta. Now, very briefly, the Sales of Goods Act is a statute that governs the contracts that involve sales of goods, right? The Supply of Goods Act provides additional rules on implied terms with regards to contracts involving the transfer of the property in goods and also of the hire of goods. The Hire Purchase Act regulates the form and the contents of hire purchase agreements. All of these are relevant, but beyond the scope of what we can cover today. What we will focus on would be the Consumer Protection Fair Trading Act, Cpfda, very easy to remember, CPF, everybody remembers the CPF, and the TA, and of course the Unfair Contract Terms Act, the Ucta. Now all these statutes are publicly available. So you can go to the web page I've indicated at the bottom of this slide, sso.agc.gov.sg, and you can download them yourself. I've also given a soft copy to the administrators of the National Silver Academy, so you can ask them for a copy of it if you wish. All right, so what are your protections? What are your rights? The way to understand it for today's session is to think of it as three different buckets. The first two buckets, the red and the yellow bucket, arise from the Consumer Protection Fair Trading Act. The third bucket, the purple bucket, arises from the Unfair Contract Terms Act, the Ucta. So the red bucket protects consumers against unfair practices. The second bucket, the yellow bucket, is what we call the lemon laws, right? It is something that gives consumers additional rights over and above all the other rights, but only with respect to non-conforming goods. Now, this amendment, I would say, to the Cpfda that gives you the lemon laws was passed by Parliament, I think, around 2012. So it's a fairly more recent development, and it provides additional rights. It provides easier remedies, easier recourse for you as the consumer. Now, the third bucket coming from the UCTA operates in a slightly different way. Instead of directly helping consumers, what it does is that this statute limits the extent to which liability can be avoided through contract terms. Now, the party who is normally using these contract terms to avoid liability would be the seller, so the counterparty to you as the consumer, right? So this particular statute limits their ability to avoid liability using contract terms, and therefore is a protection and a help to consumers. Now, let's go through them in some detail. So for the first bucket, the red bucket, it protects consumers against unfair practices. So first, we need to understand what are consumers, who are consumers. So you and I are consumers to the extent that we are entering into a transaction not with a business intention, not as a business, right? So let's say, example, I have a used laptop and I want to sell it to my friend or to my colleague, then I am a consumer. Or if I want to buy your used laptop, your second-hand laptop, then I would be a consumer interacting with you. Of course, the Cpfda is a statute in Singapore. It's a statute, it's a law in Singapore. So in order for it to operate, you must remember that the buyer or the seller must be resident in Singapore, right? Or the offer and the acceptance for the transaction must be made in or from Singapore. Now, as far as the first bucket, the red bucket, is concerned, it covers not just goods, but also services. Now, what are the general rules? What are the unfair practices that the red bucket, the first bucket, protects you against? Number one, it protects you against deceiving or misleading, right? So if the seller were to deceive or mislead you, that would be an unfair practice. Number two, it protects you against false claims. The seller cannot make false claims. Number three, it protects you against sellers who try to take advantage of you. Now, these are general rules and we need to understand them a little bit better, right? When I say you are protected against deceiving or misleading statements or acts by the seller, you must remember that it includes both what he says and what he does, right? It is something that he says or does that could mislead you or that could deceive you. But it's more than that. Sometimes he tells you only half the story. The seller tells you half the story and remains silent on the other half. So the act of omission, the act of silence, the act of not doing something or not saying something can also lead to unfair practice because it can also lead to deceiving or misleading you. Okay, so deceiving or misleading can go beyond what he says or what he does, he meaning the seller. It can also go to what the seller does not say or does not do. Okay, that's number one. That's the first category. The second category in the general rule is the false claim. If the seller were to make a false claim and to say something and claim something about his good or product that is not true, then that would be an unfair practice. The third category of taking advantage is when the seller tries to take advantage of a consumer who is unable to protect himself, right? Or perhaps the consumer doesn't understand. He doesn't understand the language of what just happened. He doesn't understand the nature or the context or the effect or the character of the transaction, right? So all of this would be part of taking advantage. These are the general rules. To help us understand the general rules, what the Cpfda has provided in its scan schedule, which, by the way, I've also given a soft copy to the administrator of the NSA, is a list of 24 examples. Now, it's important to note that these are just examples. They are not exhaustive, meaning that there can be more than that. But of course, if you can identify your situation to be one of these 24, then it's very clear. If you cannot identify within one of these 24, you go back to the general rule, the three general categories of deceive or mislead, or false claim, or taking advantage. So let's go through a few examples, right? Number one, for example, approval, characteristics, or benefits that they do not have. Let's say, for example, the seller represents to you, tells you, right? He tells you that this particular goods has the approval or the support or the endorsement of some famous actor or actress, when actually this famous person doesn't actually endorse or approve it. That would be an unfair practice. Another example, right, of standard, model, origin, method of manufacture that they are not. So for example, if the seller were to tell you, to represent to you that this particular car is manufactured in 2020, it's a 2.3 liter engine, it's made in Japan, right? When it's not, when it's made in Thailand, or when it's only a 2 liter engine, or perhaps it's a 2019 model, then that would be an unfair practice. Another example, when the seller tells you that a product or a good is new or unused when they are not, right? So he tells you, for example, this laptop is new when actually it's a second-hand laptop. That would be an unfair practice. Sometimes the seller could tell you that there's some sort of price advantage or benefit when there isn't such a benefit, right? So let's take an example. Let's say the seller is selling you a wallet, and he sells you the wallet, a leather wallet, for say $100. And then he tells you, you know, you buy one is $100, but you buy two, I'll give you a special discount, a special price. Buy two at $80 each. Okay. Now, of course, that is a benefit to you, but if he has always been selling and will be selling a wallet by itself for $80, then he is representing to you an advantage which you don't actually have. And that would be an unfair practice. Another example, discounted price available for a stated period of time that is longer than what is stated. Okay, so you see this sometimes, right? The shop will say closing down sale until, let's say, end of December 2020. But then in January, you go back, you realize, the sign is still there, it's still closing down. In fact, it seems like closing down for months and months, it never actually closes down, right? So that is an unfair practice because the seller is telling you or representing to you that there's a discounted period only for this period of time, when actually it goes even beyond this period of time, okay? All right, some more examples. Charging a price that is substantially higher than the estimate provided. Let's say you bring your car in for servicing and the workshop says, okay, the estimated service cost to repair this and that is $500. And then at the end of the day, you go back to collect your car and the workshop tells you, oh no, it's $1,000 or it's $2,000, right? Now that is an unfair practice because now the workshop is charging you a price that is substantially higher than the estimate which they had provided. Another example, sometimes you have the seller including terms in the contract that are harsh or oppressive or excessively one-sided. What does this mean? Sometimes when you buy something, they make you sign the contract and the contract may have a term. And the term may say, for example, no refunds under any circumstance, right? A statement like that, a term like that in the contract is harsh, is oppressive, is actually very one-sided. And that is an unfair practice, right? And you must remember, sometimes these terms don't have to be in the contract. Sometimes they can just put it as a notice on the table, on the door, on the wall, right? And then they claim and then they point to the notice and they say, because of this, therefore you cannot have a refund, right? But you can't do that, or the seller cannot do that, because if this term is excessively one-sided or oppressive, then it would be treated as an unfair practice. Now, sometimes the seller could try to exert undue pressure or influence on you to enter into the contract. He could say something like, you know, this offer is only good until now. Once you walk out the door, it's gone. Or he may say, I have other customers, and if you don't want it, take it or leave it, right? Exerting pressure on you to quickly close the deal, to enter into the deal at that point in time. That could be an unfair practice. Another example in this 24 list of 24 is omitting material facts or using very, very small fine print so that it's very hard for you to see in an attempt to conceal something that's important to you, right? So if you find that the notice saying something, let's say no refunds, right, is in a very small print in one corner here, on the wall here or there, they are trying to conceal, they're trying to omit a material fact. Now, these are examples of what you can catch under the first bucket, the red bucket, right? The red bucket of protecting consumers against unfair practices. Again, I repeat, if you cannot identify your situation to one of these 24 examples, you can go back to the general categories of deceive or misleading, a false claim, or taking advantage of you. Okay. Now, if you find that there's an unfair practices, then you have a legal recourse against the seller. Now, I'm going to move on to the second bucket, to the yellow bucket. Right? The yellow bucket are the lemon laws. The lemon laws, as I mentioned earlier, were enacted by Parliament a bit more recently, and they apply to essentially to goods, right? Because they apply to the contract or sale of goods, they apply to the contract for the transfer of goods, as well as to the hire purchase agreements, right? Now, again, it's a Singapore law, so the goods must be purchased in Singapore. And what could these goods include? These goods could include things like computers, laptops, TVs, stationery, furniture, bicycles. It could include things like second-hand equipment or display equipment or discounted equipment. Now, just be careful and mindful that if you buy a second-hand good, then of course you must be reasonable about it. If you tell me what is the satisfactory quality of a second-hand good, it is dependent upon how old it is, how much you pay for it. You cannot actually expect it to be like new. Okay, so this is what the lemon laws apply to. The lemon laws do not apply to certain things. So the point about the lemon laws, the second bucket, is that they were enacted later to give additional protection, but on a narrower scope of products. Okay, so it does not apply to services. Let's say, for example, you have an employment contract, right? That is a service, and that lemon law does not apply to this sort of services. It doesn't apply to real estate or property. If you want to buy a property, buy a condo, it doesn't apply. It doesn't apply to rental or lease goods. So if you want to, let's say if you are renting a car or a bicycle, the lemon laws do not apply. It doesn't apply if in consumer to consumer transactions. So I'm a consumer if I'm not a business, and if I were to transact with somebody else who is also a consumer, then it's a consumer to consumer transaction, and then the lemon laws do not apply. Neither does it apply to a business transaction. If I was running a business, let's say, for example, I buy and sell computers, and you are, maybe you also buy and sell computers, or you repair computers as a business, right? Then a transaction between the two of us would be between two businesses, and it doesn't apply. The lemon laws apply when you're a consumer against interacting with a business. Right. So what do these lemon laws protect you from? They protect you in situations where the goods do not conform. Okay? In other words, where the goods are defective. So the way the law, the statute writes is when the goods do not conform, and we need to understand how you can determine, how you can assess whether the goods provided by the seller do not conform. In other words, whether they are defective or not. Now, there are three ways for you to assess this. Number one, sale by description. Number two, sale by sample. And number three, whether the goods provided is of satisfactory quality. Right? So let's explain them one by one. Sale by description. When the seller sells you something by description, then the good that he provides must conform to that description. If it doesn't conform, then that would be it would be a defective good, and therefore would be caught under the lemon laws. So for example, right, I go to a camera shop and I want to buy a camera, and they tell me this camera is made in Japan. Okay? But actually it's not. It is actually made in Thailand. Then that would be a defective goods because it doesn't meet the description as given to me. Another example would be a sale by sample. Sometimes the seller may just show you a sample, right, and provide you with the goods based on the sample. Now, when the seller sells you something by sample, the requirement is that whatever he gives you, it must conform to that sample, right? It must be the same as that sample. So when he gives you the sample, you have a chance to see it, to observe, to check whether there are some defects or not, right? Now, remember, if you can observe the defect and you can see the defect, and he gives you something with that defect, then that's fine because you could see the defect. But if it's something that's hidden, something that you cannot reasonably observe or detect from your inspection, then that would still be a defective good if what he supplies to you is defective in that way. Okay, so I give an example. Let's say you buy a camera lens. The lens is given to you, and the lens, you can see, well, okay, there are no scratches, there's no, you shake it a little bit, there's no sound, there's nothing loose in it. That's your inspection, that's a sample given to you. But if that sample has some mechanical problem, let's say the focusing mechanism doesn't work properly, and you cannot actually detect it through your observation, right? And he gives you something that doesn't focus properly, then that good would be defective. Now, another category, the third category for defective goods would be whether the goods are of satisfactory quality. Now, this is very subjective. So we again try to give some guidelines and rules on how you can determine whether the goods are of satisfactory quality. Satisfactory is always in law in the eyes of a reasonable person. You must always be reasonable, right? So what is satisfactory is what a reasonable person would consider to be reasonable, taking into account the description and the price that you paid for it. And whether it is satisfactory or not, it can include things such as the appearance or the finishing of the goods. It can be the, for example, the durability of the goods or the safety of the goods, its freedom from minor defects, and very importantly, whether it is fit for its common purpose, right? When you buy a good, it will be defective if it's not fit for its common purpose. And I want to, at this point, emphasize on the word common. Because common purpose is what is the usual purpose of that good. For example, if I were to buy a camera, then the common purpose of the camera is to take photographs. And if the camera cannot take photographs, then it will be defective. Now, the rules, you cannot say that the product is not satisfactory in quality if it is not fit for a particular purpose, a purpose that is not its common purpose. So for example, if I wanted a camera that I can use for scuba diving, I can dive with it and I can go down 10, 20 meters and I can take photographs of the corals at the bottom of the sea, right? That is a particular purpose. That is not a common purpose for cameras. And therefore, if the camera cannot take photos underwater, then that is not defective. Unless when you first buy the camera from the seller, you tell the seller what your particular purpose is. So this is important. If you tell the seller, I want this camera to be able to take photographs under the sea, under 10 or 20 meters of water, and to take photographs of the corals, and the camera is unable to do it, then it is defective. It does not conform. It is not of satisfactory quality. So what is important here is that if you have a particular purpose for what you're buying the goods for, you must tell the seller at the point where you are buying it. You cannot tell him after you bought it. So at the point when you are negotiating, talking to him, in law, we call it at the point of formation, at the point of contract formation, right? You must tell him of your particular purpose. And there's one caveat, one catch to this. It must be reasonable for you to rely on that seller's skill and expertise when you're telling him the particular purpose and he says yes, right? You tell him, I want this camera to be able to take photographs under the sea, in the water. It must be reasonable for you to be able to rely on that seller's skill and knowledge. What does this mean? Let's say, for example, the seller in that particular case happens to be a teenager. He might be a 15-year-old student working part-time during the school holidays, and he tells you, yes, the camera is suitable, right? But you may not be able to reasonably rely on that 15-year-old temp worker or trainee or student when he tells you that the camera is suitable to be used in the water. What you may want to do then is you want to ask the manager or a more senior person, a more senior sales representative, or better still, the owner of the shop, right? If you do that and you tell him your particular purpose and he tells you, yes, it can, then if it doesn't conform, if it cannot, it's not suitable for that purpose, then the goods will be defective. Now here, I must also mention, be careful, right? You cannot say that a good is defective if you yourself damaged it, right? Or if you tried to repair it and you damaged it in the process, or it's been through wear and tear after a number of period of time, it has worn down, right? So you can't say that. Neither can you say it's defective if, after you've gotten it for a few months, you decide you don't want it anymore, right? That is not defective. So again, we must be reasonable. Now, what is the process if the goods are defective, right? Here, the second bucket, the lemon laws, make it easier for you, I would say, as a consumer to find a recourse against a seller, right? So there are two steps in the process. The first step is very simple. Once you have identified that the goods are defective, you ask the seller to either repair or to replace the goods. And he has to do so, right? He has to do so within reasonable time. He has to do so without causing you too much inconvenience. And if in doing so, in repairing or replacing, he has to incur some labor or material or postage costs, etc., then it's the seller who has to pay for it. Okay? But again, we must be reasonable. So let's go through with some examples. Let's say you buy a shirt and the shirt, the button falls off, right? It is not reasonable to ask the seller to replace the shirt because he can repair it quite easily. All he needs to do is to sew the button back. He can do so in a very reasonable time. He can do so without causing any significant inconvenience to you. So he can repair it, okay? Let's say you buy a table and the table has 4 legs and one leg is wobbly, it's not stable, it's shaky, for example, or maybe it's too long or too short, right? Then you go to the seller and says, look, I want you to either repair or to replace it, right? So if he can replace the leg. If he cannot repair the leg, then he has to replace the whole table for you. It depends on the nature of the table, okay? Now, sometimes you cannot ask the seller to repair or replace. You need to recognize when, right? You cannot when it is either impossible for the seller to repair or replace, or where it is disproportionate, where it is unreasonable. So the best way to explain the game is through examples, right? If, for example, going back to the table example, right? You buy a table and one leg is wobbly and you want it to be replaced and he tells you he can't because that's the last example of that table that he has. He has no other table like that anymore. So he can't replace it, okay? And then he may say, well, why don't you repair it, okay? So let's say you buy the table for $100 and to repair it, perhaps because of a labor shortage or because it's designed to be mass produced and repairing one particular leg is very difficult. Let's say it costs more to repair than to replace. Then the seller can legitimately tell you it is unreasonable because it's disproportionate. Because it costs $200 to repair the table when you only paid $100 for it. Okay? But don't worry, just because it's impossible and disproportionate doesn't mean it stops here because this is only step 1, right? You still have a step 2 solution. But at this point, I want to highlight 2 other reasons why sometimes step 1 is not enough. Sometimes, even when the seller agrees to repair or replace, if he takes too long, beyond a reasonable time, then you can go to step 2, right? Or if it causes you significant inconvenience, then you can go to step 2, right? So let's take an example. Let's say you want to buy, you bought a handphone, okay? And it's a second-hand handphone, and the handphone is defective in some way, right? As described earlier. Now, then the seller says, okay, I will repair it for you. And he takes it away 1 week, 2 weeks, 3 weeks. He returns it to you. It's still damaged, it's still defective, right? He tells you, oh, come back again, use it for 1 week, come back again. Then you ding dong a few times. It's taken you a few weeks, taken you a few trips. That is not reasonable because the timing is not reasonable. It has caused you significant inconvenience. The way to understand whether the timing is reasonable or not, or whether the inconvenience is significant or not, depends on the nature of the goods and the purpose. So if you buy a handphone, how often would you use a handphone? You probably use it all the time, every day, a few times a day, right? And therefore, the time cycle to repair it will be shorter. In contrast, let's say you buy a camera. How often will you use a camera? You might use it on the weekends when you go to the botanical gardens. It might be perhaps only 1 month later if, without COVID, you'll go for a holiday, for example, right? Then I think the seller will have more time, a longer time to repair or to replace it, and it will still be reasonable. So it depends on the nature and the purpose. Now, regardless of the outcome, if it is impossible or disproportionate for the seller to repair or replace, or if he has taken so much time that's not reasonable or has caused you significant inconvenience, then you can go to step 2, right? What is step 2? Then you simply ask the seller to either reduce the price or to refund, right? So reduce the price means you keep the goods, but you give me a discount, or a refund means I return the goods to you and you pay me back what I paid you, okay? Now just be careful. One caveat here is that, of course, if you have already used the goods for a number of months, then I think it is fair and reasonable for the seller to also reduce the refund, the amount of the refund, right? So let's say you buy a fridge, it's supposed to last you 6 years, and you have used it for half the time, 3 years, and then there's a defect, right? A defect that came, right from the beginning, and then you go back to the seller and you paid $1,000 for it, then he might refund you maybe 50%, okay? Maybe a bit less because, the first time that you use the front end period of time when you use the goods, normally the depreciation is faster, okay? But you understand the idea. The idea is to get a refund based on how much time you have used it and based on the natural lifespan of that good. Now, there's something else that's important with regards to the lemon laws. It is about when you detect the defect. That makes, it's quite important, right? When did I find out about that defect? Now, let's go to the right side of this table first. If you found out about the defect after 6 months from delivery, in other words, after 6 months from receiving the goods, then the burden of proof, is for the consumer, for you and me, to prove that the defect actually existed at that time of the delivery. It's quite hard to do this because you already had it for more than 6 months, and then you say that, oh, you must prove to the court, to the seller, that actually that defect, that problem with it, was always there right from the beginning, okay? On the other hand, if you discovered the defect within 6 months of delivery, before 6 months, then the law will presume that the defect was always there right from the beginning, and you don't have to prove anything. Rather, the burden of proof is reversed, and the seller has to try to show otherwise, okay? So let's take an example. Let's say you bought a pair of shoes, and within 6 months, you realize that the sole is falling off or the leather is cracking, okay? Now, because you detect the problem before 6 months, the law will presume that the defect in the shoe was always there, was there right from the beginning. And then it is for the seller to say that, oh no, the defect wasn't there. It's because you never use it properly, because you abuse the shoe, you misuse the shoe, you never take good care of the leather or whatever. But if you only detected it after 6 months, then you have to prove that the defect was there right from the beginning. How can you do that? That's quite difficult, right? Unless you have some sort of evidence, some photograph or something to show that the defect was there right from the beginning. Can be quite difficult. So the point really is try to identify the defect early, before the 6 months, and then it makes your remedy and your recourse against the seller much easier. Okay, so what do you do when you have a defective good, right? You go and talk to the seller. Because once you talk to the seller and you tell him that you know and understand the lemon laws and the unfair practices under the first red bucket, then he will normally play ball with you because he knows that you know. And if he knows that you know, he knows that you have certain rights and you can insist on your rights, he will normally cooperate. He will cooperate to repair, to replace, to maybe reduce the price or to give a refund. Okay? Now, if you're not sure, you can ask CASE, Consumer Association of Singapore, for guidance. They will try to assess your case for you. They can also assist in mediating between you and the seller. The other thing to remember is that the CCCS, the Competition and Consumer Commission of Singapore, have been given powers to investigate sellers who practice unfair practices. All right. So what happens here is that if they investigate, then they have certain powers to check on the seller, to interview, to examine the seller, right? To go to their premises and to see what's going on there. And as a result of that, sometimes they can get the seller may be fined, or the seller may be sentenced to jail even. Okay. All right. So that's for the lemon laws. I go quickly now to the third part, which is on the third bucket, the purple bucket, right? The UCTA. Now, here the UCTA limits the extent to which liability can be avoided by the seller through the contract terms which he includes. Okay, so the idea here is to protect consumers who are prejudiced by your weaker bargaining position. Now, the UCTA applies for the purposes of our session today if, number one, you are a consumer, or number two, if the seller uses his standard terms and conditions. Okay, so normally you and I are consumers, so that would be good enough. But sometimes if the other party uses his standard terms and conditions, that is also good enough. What is the standard terms and condition? You know, when you go to the bank, you open an account, right? The bank officer will make you sign here, sign there, sign 5 times on 3, 4, 5 pages. All the terms and conditions are printed out and you have no choice to negotiate. You have to just accept it. So the point behind standard terms and conditions is that you really just have to accept it. You have no choice. You can't really bargain about it. And therefore, the UCTA will protect you. Okay? How does it protect you? It protects you through 2 different categories of contract terms. Okay? Now, the first is absolutely not allowed, where the contract term says that the seller is excluded from liability for death or personal injury. The seller can never exclude liability for death or personal injury. Okay? So for example, you go to a theme park and the operator has a sign, right? The sign that says, if injured or die, then we are not liable. Okay? That is not valid. That is not operative because the seller cannot exclude liability for death or personal injury. That's one category in red here. Now the second category, right, is in green. Here, let me try to explain it to you, where a consumer like you and me deals with a business, and the business, meaning the seller, right, he includes a term in the contract. It doesn't have to be in the contract. Sometimes it can be just a notice. So either he has a term in the contract or he puts a notice, and that notice or that term says that it excludes the seller's liability for a breach of term, okay, or it limits the seller's liability for breach of term, or the term or the notice says that the seller can perform substantially different from reasonable expectations. Okay? Either one of these. That clause, that notice, right, is not operative unless it can be shown by the seller to be reasonable. Okay? So in other words, it's actually not operative unless the seller can show it is not reasonable. And then the question is, what is not reasonable? This is where it gets a bit more subjective, right? What is not reasonable? So again, the UCTA provides some guidelines under it's also the second schedule, some considerations as to whether a particular term or a particular notice is unreasonable. One consideration would be the bargaining position of the parties. Is one party much stronger than the other? Is the seller in a much stronger position? Does the buyer have no alternative? If that is the case and there's an imbalance in power, then that term could well be deemed as unreasonable and therefore not operative. Another example would be whether the consumer receive an inducement to agree to the term. Right? So sometimes, let's say the seller tells you, okay, this is the term says no refunds, but I will give you a 50% discount. That 50% discount is an inducement. It is something to facilitate the agreement, to make it, to induce you to agree to that term. And if that is the case, then the law will treat it as more reasonable, likely to be reasonable, because you were given a discount, you were given an inducement to accept that term. Another example is, another consideration is whether the consumer knew or ought reasonably to have known of the term. It depends on whether the term is highlighted to you. Is it hidden in some corner in a notice and small little words in some corner somewhere? Or did the seller actually point out to you? Right? He draw an arrow, he show a red finger, and he made you sign against it. Right? If you knew about it, it's more likely to be reasonable. If you didn't know about it, or you cannot reasonably know about it because it's hidden somewhere, not drawn to your attention, or it's in very fine print, then that would be more likely to be unreasonable. Another consideration is whether the goods were manufactured or processed or adapted to a special order of the consumer. Okay? In other words, is that particular good custom designed for you? Now, normally the seller would sell standard goods, goods that he always sells, but sometimes you want him to do something special. You want him to change something, to modify something. If it's a custom-made goods, right, then it's more likely to be reasonable because you must, if you think about it, right, then the seller has to take some additional risk. Maybe he doesn't know how to make it as well. It's not what he usually does, right? And therefore he wants to have some terms to protect himself, to limit his liability. So that could be a reason to say that it is reasonable. Another consideration, if the term excludes liability, if some condition is not complied with, then the question is whether it was reasonable at the time when you enter into the contract, when you agree to buy and sell, right? Whether it can, it's reasonable that you can expect that compliance was practicable. Okay, so again, it's all about reasonableness or not. Okay, so these are the three main buckets, and I want to give a quick summary. Remember the three buckets of protections that you have. Let me just go back to the correct slide. Okay, is red bucket, protect consumers against unfair practices. What are unfair practices? Unfair practices are when the seller tries to deceive or mislead you, when he makes false claims, or when he takes advantage of you. Okay. The second bucket is the lemon laws. This is specific to goods, non-conforming goods. Therefore, you must assess whether the goods are non-conforming, whether they are defective, right? And you can assess that quite quickly by looking at three categories. Does it conform to the description? Does it conform to the sample? And is it of satisfactory quality or not? Bearing in mind that with satisfactory quality, it should be fit for its common purpose. There's no requirement for it to be fit for a particular purpose unless you tell the seller your particular purpose. So I would advise you that if you wanted to be sure, you would tell the seller what your particular purpose is. And you must tell him before you buy the thing. So at the point of negotiation, at the point of forming the contract, you must tell him your particular purpose. And of course, the third bucket is the purple bucket, the Ucta, which is all about the contract terms, right? If the seller were to include a contract term, let's say in the contract, or he puts a notice on his table, on the door, on the wall, and that either that term or that notice tries to exclude or limit his liability for a breach of term or for not performing properly, then that term can be, in some cases, be invalid if it's not reasonable, and it's definitely not valid if it excludes liability for death or personal injury. Okay, all right, now that's a quick summary, so I think we will take some questions here. All right, so I see first question, does it apply to purchases on online stores? Yes, the lemon laws do apply to online purchases. Just bear in mind that, of course, if the counterparty is not in Singapore, you're going to have practical problems trying to find him. All right. So again, the laws are in Singapore, you are in Singapore, and these are, I would imagine, normally for fairly small items, right? If the seller is can't be located in Singapore, then you have a difficulty with that, right? Remember that the goods must be purchased in Singapore. Okay. Another question. What if the seller tries to hard sell to me that I need to buy or use a particular service or good? Now, here, it's potentially an unfair practice, right? It's unfair practice in the sense that if the seller knows or ought reasonably to know that you actually don't need that particular service or good, then he would be deceiving or misleading you. Then it would qualify as an unfair practice. Okay? All right, next question. If I buy a used car and later find that the car is faulty, what if the seller insists that the car is of satisfactory quality because it is a used car? Okay, so here, remember, when you buy a used car, of course, you must take into account certain considerations as to what would make it satisfactory or not. Okay, now, what are the things that you would take into consideration? Right, it's a used car, right? So ask yourself, how old is the car? How much do you pay for it? What is the car's history? What's the mileage that it has been driven to in the meter? What is your intended use, right? Was there any description about the car made by the seller? Did the seller tell you this is a great car, this is a perfect car, new engine, whatever the case is, right? And then you ask yourself things like, is the car safe, right? Is there some safety concerns? Is there some durability concern? All of these factors you have to take into account to ask yourself and to assess whether it's of satisfactory quality or not. Okay, so you take that all into account, and it's about how a reasonable person will assess these things, but you take into all these factors into account. All right, another example, it says, another question, sorry, yeah. Does satisfactory quality apply to goods which I pay by installments? Yes, because if you look here, let me just show you, under the Lemon laws, right? The Lemon laws include hire purchase agreements. Okay, so the Lemon laws apply to this. Okay, question 5. Online purchase. Purchase a dog pee tray with white stains, and seller said that it is cheap and I could not expect item without defects. Seller did not state this online, his online site, that item has stains. Can the Lemon law be applied? Okay, so what exactly did this one is a bit more difficult to answer because it depends on what the seller showed you or told you. Now, if the seller had showed you a sample and a picture, then it could arguably be under a Lemon law issue with regards to by sample, right? It could be defective because it doesn't conform to the sample. Now, if he described it to you, right, and he tells you it's a new, it's clean, then that could well be again an issue under the Lemon laws. It could be caught under the Lemon laws. Now, if he tells you it is cheap, it's the price alone. Now, of course, when you ask yourself whether something is of satisfactory quality or not, you must take into account the price and the description. Okay, so if he tells you it is cheap, then that is all right. That is something which I think is a bit subjective, right? Again, without knowing the price for the tray, right? What's the usual price? How much cheaper it is? Then it is an issue of it's subjective. Okay, so you might have a case because if he, because there is a stain on it. At the same time, because it is cheap, it's a sense of how cheap it is relative to the goods that you paid, right? So this one, I think I can't directly answer. If he had showed you a picture or a description, I think it will help your case a lot more. Okay. Okay, question 6. For UCTA, what does limiting liability mean? Okay, so you see here, sometimes the seller would add a clause into his contract to say that, for example, right, if something were to happen, if I were to breach my term of the contract, I'm not liable for the breach. Okay? Sometimes he will use a limitation clause. He will say that if I were to breach the contract, let's say he will sell you a car and the car is worth $50,000. He says, if I breach my contract, then my liability is limited to $100. Okay? So a limitation clause limiting liability is to put a dollar amount to limit the amount that he's liable for. And that can be reasonable or unreasonable depending on the rules that I described earlier as well. Okay. Can I terminate the contract which has signed with a telco without good network coverage in my house? Okay, now this is again difficult to assess offhand because it depends on what your contract says, right? The contract may have certain terms, and if the terms are unreasonable, then you may want to consider checking whether it violates the UCTA or not. Okay. When you say telco, again, it's a bit vague. Are you talking about a Wi-Fi, a network system? I think it's not a landline. I think you're referring to Wi-Fi, right? I'm not sure. Okay. Wi-Fi, there can be valid reasons why it doesn't work properly in the house because sometimes the signal can be attenuated, can be destroyed by your walls, by the corner that you put it. And it's also not just dependent on the telco provider. If my memory is correct, it also depends on your router, right? So the quality of your device, how much you pay for it. So all of it is taken into account now. Okay, so it's a bit difficult to go into more details on this one. Okay, all right. So it seems like that is the end. There's So the thing here is that there is, okay, give me a second, remind me later. Yes, okay. All right. So I think this is the end of the question. So I think we'll call an end to the session. Let me just bring you right to the end, to the last slide, which says, okay, if you find this talk useful, please like it, share the video with your friends and your family. If you want to know more about your consumer rights, the lemon laws, I've given a link here for you to go and click on it. And of course, if you want to learn more about the sort of sessions that the NSA, the continuous learning opportunities, you can go to the NSA webpage or call this number here and find out about other learning opportunities. All right. So thank you for your time. I hope you found this useful and exciting. I mean, I am excited to share this with you, and if it's just helpful for some of you, I think that would make me rather happy already. All right. So thank you very much, and have a good afternoon.